Hello everyone and welcome to this Lexology webinar. My name is Umair Rahim. I'm an editor here at Lexology and I'd like to thank you all for tuning in. We have a really great presentation lined up for you today from Hall Benefits Law on post-pandemic employee benefits considerations, a closer look at the new normal for employers. Before I hand over to the speakers, I'd just like to go over some admin points before we get started. If you have any audio-visual problems during the presentation, please let us know by using the online question tool and we'll do our best to resolve them. The recording of this session and the accompanying slides will be posted online and we will send a link to all webinar attendees. Please use the link and send on to any colleagues who you think may be interested in today's presentation. So without further ado, I'd like to hand over to David Hall, who is the firm's Chief Marketing Officer, to get started. David?
Umair, thank you so much. We are excited to partner once again with Lexology and appreciate the platform that Lexology gives us to get this content out to plan sponsors, to the service providers who are serving plan sponsors, and to the attorneys, both in-house counsel and outside, who are helping plan sponsors. That is our mission as a law firm. Just as information for those of you who are on the call, we are a boutique ERISA law firm headquartered in Atlanta, Georgia. We serve clients currently in 29 states. The slide that you're looking at now is simply a reminder that if you have specific questions relative to the webinar, you may submit those in two ways. The first being to email that question to admin@hallbenefitslaw.com. The second method by which you may submit questions is actually through the GoToWebinar control panel on the side of your screen. If you click the arrow next to questions, you can type your question in, hit enter, and then your question will be submitted to our team. We will not be answering questions today on the webinar because of the amount of content that we have to go through. We want to make sure that we get all of that in your hands. One last note, speaking of content, we have 3 recent COVID-19 articles that our team has authored. 2 other articles have been published since the creation of this slide, and everyone who registered for this webinar will receive a link to our COVID resources page, as well as a copy of our principal attorney's book, Case Studies in ERISA. I hope this session is useful for each and every one of you, and I look forward to hopefully working with some of you in the future. Now I'm going to introduce our presenters. Eric Schillinger is Senior Compliance Counsel here at Hall Benefits Law. He's going to be presenting on the health and welfare aspects of COVID-19 and the changes that COVID-19 and the legislation relative to this pandemic have brought to the health and welfare benefits space. And then Scott Santerre, Senior Compliance Counsel, and Robert Foreman, Lead ERISA Counsel here at Hall Benefits Law, are going to then focus on retirement plans and executive compensation. So without further ado, I'm going to turn the program over to Eric. And again, thank you to Lexology and thank you to each of you. Eric?
Thank you, David. So in the health and welfare context, I know we're focused on the new normal. Actually, the first piece of guidance I want to talk about is more of an immediate concern, but it's new guidance is relevant, significant, so I wanted to cover it. And that has to do with cafeteria plans, health and dependent care FSAs, and high-deductible health plans. There are several pieces of guidance in there. The main part involves some new mid-year permitted election changes. The others involve health FSA and dependent care FSA grace periods and carryovers. And then third is another expansion of telehealth coverage, which I'll mostly talk about in the slides after that. And on that topic with telehealth, when we get the new normal, for those of you who have been to the doctor in the past couple months, you probably at least had 1 or more visits in telehealth. So right now it's obviously very expanded, and we think there's probably a good chance it'll continue to be a popular approach even after the pandemic sort of subsides. The next involves HIPAA, and in the prior webinars I've talked about HIPAA first in the context of what kind of protected health information and under what circumstances a group health plan can disclose COVID-19 related information without a participant's consent. I've also talked about considerations for remote workers. And so the third topic I wanted to talk about has to do with cybersecurity. There's been a lot of issues with hackers trying to exploit COVID-19 for financial gain. So I think those are important considerations even in the employment and employee benefits context. Next, I'll also talk about business travel insurance, and this has been popular even before COVID-19, but I think even also after the pandemic subsides, I think we may see a lot more of this. So I wanted to cover a few legal considerations for it. And then lastly, voluntary insurance benefits. Certain industries are already very popular, and they've been pushed more and more as the ACA was enacted. And I think they will probably continue to be very popular even after the pandemic. So there's a few considerations there as well, particularly with an ERISA exemption. So in terms of new IRS guidance, and this was issued this month, the first component I'll talk about are the FSA carryover amounts. So they're an optional feature for health FSAs, and a health FSA can have either a carryover up to $500 before this guidance, or a grace period. A grace period is essentially an additional period after the end of a plan year where participants can submit claims for expenses incurred during the grace period. That's different than what's called a run-out period, which is essentially just an expanded deadline to submit claims. So what this guidance did was it permanently increased the amount that could be carried over from year to year to $550 starting 2020. So this would apply to amounts that you carry over next year into 2021. And this is the first time this has actually been increased since 2013 when the concept was created. So in terms of a plan sponsor that wants to adopt this, I think most plans are going to need an amendment, usually a cafeteria plan or FSA plan document that has a carryover is going to specify that it has to, and then it's going to specify $500 because that's what the rule has been to date. So such a plan is probably going to need an amendment. The only instance where maybe it wouldn't is if you have a plan that just references the statute. So then where guidance subsequently increases the amount, I guess your plan would be automatically updated. I doubt that's the case with most plans, so I think an amendment will be needed. Fortunately, this isn't something that has to be done this very second. Basically, you need to do it by the end of the year to allow carryovers. You also must inform employees of the change, and then also importantly is that there's going to be the need to coordinate with the administrator, right? You can't just amend your plan, send out an email to employees and expect everything to work out. The administrator is going to have to program their system. So this is probably the biggest change in the guidance, and I think it's a big deal. On our prior webinar, I talked about whether health plans could allow a special enrollment event just because of COVID-19 considerations for employees who waived coverage to now get in. At the time, this guidance wasn't out, so I had mentioned that if a plan decided to allow the special enrollment, it probably couldn't allow employees to pay on a pre-tax basis. This new guidance changes that. And so it affects cafeteria plans. And just to give a little context, the cafeteria plan is not like a health plan, it's not life insurance. All it is it's a mechanism for your employees to have pre-tax payroll deductions and avoid a concept called constructive receipt. So these rules basically allow these changes of pre-tax withholding. They don't govern the underlying benefits, such as a health plan. So, and there's 5 of them, and I'm going to list them in the following slides. But basically, if a plan wants to take advantage of this, unfortunately, it doesn't require an amendment up front. You have to amend it by the end of next year. And then, of course, coordinate with the vendor to ensure correct administration. Also, you must inform employees of the change. A cafeteria plan is not an ERISA plan, so it doesn't trigger an SMM requirement, but certainly as part of the guidance, you're required to inform employees of it. And as a practical matter, the change is essentially useless if nobody knows about it. So the first of the 5 changes is mid-year enrollment. So a plan can allow employees who decline coverage, i.e. in open enrollment for 2020, to make a new prospective election change to pay for coverage on a pre-tax basis. So, for example, someone who declined health coverage that wants to now enroll, you could choose to allow that. Now, you don't have to. But if you wanted to adopt this event, the main thing you would need to do is ensure if you have an insurance carrier, you'd want to get their approval, or if you're self-funded, you would probably want to run this by the stop-loss insurer. And the reason is because these rules govern cafeteria plans, so you're still bound by the terms of, say, the insurance plan. And carriers often have a consideration with a concept called adverse selection. The idea that if you allow this new event for everybody to get in, now at this point, sicker people are likely to take advantage of it. And although, as a general matter, most insurers have allowed these special enrollments for COVID-19, you're still going to need to get their approval. Otherwise, you kind of run the risk of essentially, if you promise this new special enrollment event to employees and the insurer says, no, we're not going to cover it, you run the risk of having to self-fund the claims, which could be very costly. The next permitted election change is to allow someone to change their plan option or dependents. So for example, if someone is enrolled in self-only coverage in a PPO and you also offer an HMO, they could say switch to the HMO mid-year, or they could add dependents to their existing plan, or both. And I think this will probably be, more popular in the context of adding dependents if a plan chooses to adopt it. The concern probably about switching to plan option, this is the case even outside of this event, is that when you do it mid-year, there's probably the risk that you're going to have to restart your deductible. And as with the mid-year enrollment, this one probably requires carrier approval as well, again, because you're allowing people to add new dependents when they wouldn't otherwise be permitted, absent another event, such as a change in employment status. The third mid-year election change is to drop coverage. So allow an employee to revoke a current election prospectively, again, so they couldn't do this retroactively, to drop coverage under the health plan. And the one extra requirement here is that this is only permitted if an employee is enrolled or will immediately enroll in other health coverage. So spouse's plan, individual market, Medicaid, etc. And so what the guidance says is that you can rely on a written attestation from an employee, and actually the IRS website, they provided a template that you can use. And it's just a basic certification that says, I am going to enroll, or I already have enrolled in other coverage. And then the fourth and fifth changes are for health and dependent care FSA elections. So again, normally you would need a particular change in status or another permitted election change event. This allows generally for employees to increase, decrease, cancel, or enroll in health FSA or dependent care FSA mid-year on a prospective basis. I think probably the relevance of this one, well, there's a couple instances where it might be relevant, but for example, a lot of people, social distancing concerns, have put off medical procedures. So somebody who elected $2,500 to their health FSA this year may decide now that they're only going to spend $1,000, and this would give a chance to decrease the election. And I think a key consideration here is that you would want to word this to avoid a windfall, which is essentially because the health FSA rules require the entire election to be available up front to the employee. So for example, if someone elects $2,500 for a year, they could spend $2,500 in the health FSA to pay for a medical procedure in January, even though their payroll deductions haven't caught up yet. It's an ACA requirement. So if you're going to allow an employee to do this, you would probably want to limit the decrease to basically what hasn't been spent yet. So if someone's overspent and has used up $2,000 of their election, you wouldn't want to let them decrease to, say, $100. Otherwise, the employer is essentially eating the cost. The next piece of guidance from what was recently issued involves what I call grace periods. Essentially, what this has done is it allows health FSA, and again, this is optional, health FSA or dependent care FSA to extend the period by which claims can be incurred through the end of 2020 or the grace period. So normally you would have, for example, a non-calendar year or calendar year plan with a grace period. For 2019, they would have a participant could submit expenses in 2019, and then they could submit expenses through, say, the first 3 months of 2020 for the grace period. Now, again, I think with people's expenses being different or people putting off claims, this basically allows you to extend that period that you could submit your balance through the rest of the year. Now, I say here that's not available for health FSAs with a calendar year plan and a carryover. It's not that it's prohibited, it's just that it would have no practical benefit. And the reason is that for such a plan, the claims period would be the 2020 year anyways. So compare that to, say, a non-calendar year plan that ran from June 2019 through June 2020. That plan, you would have the additional basically 5-6 months to submit claims. But when you have a regular 2020 calendar year plan, there's no additional benefit. And actually, as with the calendar year or cafeteria plan changes, the amendment for this can be retroactive. It has to be done actually by the end of next year, not the end of this year. So that's December 31st, 2020. And employees, again, must be notified of this change. So next topic, telehealth benefits. As I mentioned earlier, I think that, at least in the COVID-19 context, they're going to be widely utilized until the pandemic, and I use the word ends. I don't know if that's quite the accurate term, but to where it becomes much less of a serious issue. And there's different opinions on when that's going to happen, but the general consensus apparently is that that's going to be whether there's a vaccine or what's called herd immunity, which I'm told is basically 60% or so plus of the population having contracted and become immune to the virus. From the estimates I've seen, we're pretty far from that point. I'm told that highest maybe 10-15% of the population. So we're looking at a period for, I think, at least another year, 18 months. And I've seen this grow, of course, a lot even this year, and I'm even now starting to see it advertised for pet insurance products, so telehealth veterinary visits. So there's been a lot of guidance and legislation related to COVID-19 and telehealth. We've got the CARES Act, which has allowed a high-level health plan to cover telehealth pre-deductible. And the relevance of that is to be able to contribute to a health savings account, you have to be enrolled in a high-level health plan and not have other disqualifying coverage. And high-level health plans are only allowed to cover certain things pre-deductible, namely preventive care. So this exemption allowed telehealth to be covered without the deductible, and the idea being, again, to promote social distancing. So what was changed is the new guidance made this retroactive to January 1, 2020, as opposed to when the CARES Act was passed. It became effective that date. And the thinking, at least as I understand it, was that starting in 2020, as COVID-19 was picking up, a lot of companies actually added telehealth pre-deductible before the CARES Act, and they didn't want to penalize those companies. And there are a lot of other compliance considerations with telehealth. I just want to list a couple here. Mental health parity, and this is more responsibility of an employer that sponsors a self-funded plan. If you have an insured plan, it's largely the insurer's problem, but as a general matter with the self-funded plan, and the TPAs are very versed in these rules and usually structure these designs to work, but the mental health parity rules essentially provide that you cannot cover mental health and substance use disorder benefits on less favorable terms than medical and surgical benefits. For example, if you have doctor's visits for regular services that are covered with the particular copay, and then you have a higher copay or you require prior authorization for the same doctor's visit for a mental health or substance abuse issue, that can be a violation. And it gets into even more specific things like treatment limitations. And then the other is ACA compliance. And as a general matter, what I mean by this is, I think to cover telehealth, it has to be part of a large group health plan. I don't think it would probably work in most cases to have a standalone plan that covers just telehealth. The reason being that certain ACA requirements can't be met under such a design, namely that you would cover all preventive care without cost sharing, or not have annual limits or lifetime limits on essential health benefits. So the takeaway there is, if you want to offer telehealth, I think it needs to be out of your group health plan. Next topic is cybersecurity. So as you can probably expected, hackers have certainly tried to take advantage of COVID-19 for financial gain. Some of these are more for the healthcare industry, but I think these issues could potentially come up in a group health plan context, or even just with employers and their employees. I mean, I've seen attempted theft of vaccine research reported a lot. Some interesting ones involve phishing attacks. Probably one of the more well-known ones involved a phony website that had a very convincing copy of the Johns Hopkins map of COVID-19 cases and deaths, and apparently looked very legitimate, and people visited it. they didn't realize, but the site was installing various data mining and other malware on their computers that was stealing passwords. And then another example with testing scams. I think the most common malware, at least I've heard discussed, is what's called TrickBot, and a big example involved a emails impersonating a nonprofit healthcare company that was offering purportedly free COVID-19 tests, but it was included links that were laden with malware that when people clicked on them, it installed software to steal passwords and other information. So again, I mean, if you're a healthcare provider, you're certainly at risk. I think also we all have to be aware of phishing emails and whatnot. So when we're forwarding, for example, information to employees about COVID-19 resources, some of these scams and phishing emails are quite convincing, so it's important to be on the lookout for them. And so in the HIPAA context, again, we're talking about protected health information of employees covered under a plan. HHS has listed, they have a whole page on their website about cybersecurity. So they posted a lot of material, including checklists and infographics for dealing with cybersecurity incidents, and then a whole bunch of guidance to deal with ransomware. So for those of you involved in group health plan administration, I would recommend checking out their site and looking at their resources. In terms of sort of what else to do with your plan, I mean, you have to have HIPAA policies and procedures, particularly if you're a self-funded group health plan. I think we all still have a lot of people working remote, even though the economy is still starting to open back up. So it's important to make sure you follow your policies, or if you have policies that don't contemplate remote work or cybersecurity, you may be in a position where you need to update them. And then, as I mentioned, being aware of these phishing emails and other scams. I know a lot of us use Zoom and are still using Zoom for meetings. I mean, Zoom has, some very strong security protocols in them, but as you may be aware, there's a ability to record Zoom meetings. So when you're discussing sensitive information in PHI, just be aware of the recording and how it stores and how that's shared. Next topic, business travel insurance. And this again has been popular for many years. I think it's becoming increasingly popular as COVID-19 rages on, and I think for those companies that didn't have it and didn't use it, particularly for employees traveling abroad, they may be wishing they considered it. And this can range from what you might consider kind of general travel insurance, so lost baggage, property damage, to sickness, accident, and other health benefits. Namely, for example, someone's traveling overseas and your health plan may not cover very much, at least your U.S. health plan. So many business travel health plans include medical evacuation. So a couple just key, or I think core compliance considerations. There's certainly other things to look at, but one is be aware of the policy. If you're looked at insurance policy, they're filled with various carve-outs. And I actually have seen some that exclude certain injuries related to infectious diseases. If you're looking for something to protect against COVID-19, that might be a provision to pay close attention to. And then the other is the ACA exemption. So when it comes to health benefits, business travel insurance can be exempt from the ACA. Essentially, it cannot be offered on a standalone basis and must be incidental to other health coverage, i.e. a major medical plan. Where the exemption ends is for health benefits that are comprehensive medical coverage over 6 months. So that's kind of the threshold to be aware of, is that 6-month mark. And if you have travel medical coverage that covers beyond that period, you may want to look at whether you can squeeze it into a different exemption for what are called expatriate health plans, which is a little bit of a different analysis, but I think it's something to be aware of because otherwise it's not clear that such a plan would comply with the ACA. And regardless, these are ERISA plans. So last topic I want to discuss are voluntary insurance benefits. And these are, again, they have been popular for years. I've seen statistics that they're picking up during COVID-19. And probably the most common ones you'll hear about, and there's a whole bunch. I mean, there's a whole suite of voluntary benefits. But the kind that I think has been discussed more in the COVID-19 context is hospital indemnity, which is where there's a fixed payment per day of hospitalization, and then critical illness insurance. And they're both sort of intended to cover unexpected out-of-pocket costs. So a couple key compliance consideration. One is that these are offered by brokers and they are generally on a commission basis related to the amount of premiums. And some of them can be very high. I've seen excess of 50%, I've seen higher. And there's nothing inherently wrong with that, not by any sense, but it's important to be aware of that and how that impacts the policies. And even outside the voluntary benefits context, at least when you have an ERISA plan, you have a duty to be aware of the commissions. So for purposes of ERISA, there is a safe harbor exemption for voluntary benefits. It's an important exemption because absent it, most of these plans are not set up to comply with ERISA. They're intended to be sort of a hands-off benefit, so they don't have a summary plan description, they don't have claims procedures, et cetera. And there are a number of cases about this where the exemption wasn't met and then there became ERISA issues. So there are 4 requirements to meet this safe harbor, and a plan is not necessarily subject to ERISA because it fails to meet the safe harbor, but there's a high risk of it. The first is that there cannot be employer contributions or pre-tax employee contributions. So the plan must be paid entirely by employees with after-tax dollars. So if you're trying to run this through a cafeteria plan, you're not going to meet the exemption. The next is that participation must be completely voluntary. Third, the employer cannot endorse the benefit. So in terms of case law, some of the things I've seen that violate this endorsement standard is putting it on employer letterhead or calling the voluntary benefits your plan. Things like that will cause a loss of the safe harbor exemption generally. And this last one is probably the trickiest, where I've seen the most problems arise, which is that the employer cannot receive any consideration in connection with the program other than reimbursements for actual reasonable expenses for administrative services in connection with payroll deductions. So an example of where this can become a problem is if you use a broker, there can be commissions, and often there's or at least sometimes there's an arrangement for commission offsets, which is where the amounts they receive in commissions offset the cost of other services they provide. And that's not necessarily a problem, but say, for example, where you have a broker that is helping with your ERISA plans, medical, dental, vision, and then is helping with voluntary benefits. If there's a provision that say voluntary benefit commissions offset the costs for preparing employee communications for medical benefits, that could probably be considered consideration, right? Because you're benefiting from the program by saving costs and other expenses. And if it becomes an ERISA plan, that's also an issue with what are called prohibited transaction rules, which can have some pretty hefty penalties. So I think that's an important thing to be aware of when you look at how your arrangements are set up with commissions. Now, just one other note I wanted to point out is that there are some voluntary benefits that are not going to be ERISA plans regardless. So, for example, home and auto, pet insurance. With those, you don't have to deal with the safe harbor because they're not considered a welfare benefit plan under any circumstances. So now I'll turn it over to Scott, who will discuss retirement plan considerations.
Thank you, Eric. So we're going to focus on some retirement plan. Someone's moving my screen on me. There we go. Look at some retirement plan issues, and now that a lot of the guidance and relief surrounding retirement plans has been enacted and implemented, practically, how does that impact your retirement plan, and what might you think going forward on how to implement that or things that you should do? The first thing is amendments in general and amendments related to the CARES Act. As many of you are probably aware, CARES Act added a couple of provisions related to the retirement plans where it increased loan amounts available, as well as allowed for a corona-related distribution that could be taken tax-free and penalty-free, and then repaid over the course of 3 years or taxed over the course of 3 years. For any plan sponsor that opted to utilize one of those provisions, and these provisions are optional, meaning that a plan sponsor could or could not elect to allow those, those amendments, those provisions could be enacted now and adopted at a later time. And the effective date of the adoption date of the amendment must occur by the last day of the 2022 plan year. Now, it's important to distinguish a CARES Act provision versus a regular provision. For example, if a plan sponsor opted to simply allow hardship distributions in the plan when they previously did not have them, or provide for a regular in-service withdrawal, such as an age 59.5 withdrawal or a normal retirement age withdrawal, those are not CARES Act provisions. Those are regular retirement plan provisions, and those changes, if they were to be enacted in 2020, need to be adopted by the regular discretionary amendment adoption date, which is the end of the year in which they become effective. So for 2020 changes, they need to be adopted by December 31st of 2020. As far as with CARES Act, if a plan sponsor has opted to utilize these changes, as a recommendation, I would suggest holding off on drafting the amendment for as long as possible, because most likely the IRS is going to come out with some guidance on how these amendments need to be drafted. They're either going to come out with general guidance to assist you in drafting, or they're going to provide model language for drafting. So really, while it might seem counterintuitive and it might seem more beneficial to get these amendments done immediately, it may not be, because you may draft an amendment that you think is appropriate for capturing the CARES Act changes, but you might have to change based on guidance that subsequently comes out 6 months to a year down the road. Also, if you aren't doing any changes to your plan under the CARES Act, as these are completely optional, then you don't need an amendment. So if you're not going to allow the corona-related distributions, not going to allow any of the increased loan provisions, then you don't need to amend your plan. And then also, it's important to distinguish, again, similar to distributions, the difference between general loans and those to qualified individuals only. If your plan currently does not or did not have general loans that were allowed, and you're just simply adding the general loan provision to your plan, again, that probably needs to be adopted by the end of the year in which the change is effective, which would be December 31st of 2020. However, if you're allowing loans specifically to qualified individuals, which are those impacted by coronavirus, that change you would arguably have to the last day of the 2022 plan year. And another thing to consider is a lot of changes, if you opt to make these changes under the CARES Act, it doesn't necessarily just impact your plan document. It can impact other things such as notices. And one specific example is if your plan is a safe harbor plan, you're allowed to make changes to your safe harbor plan mid-year, but in order to do that, you need to provide a updated safe harbor notice if any of those changes you enacted impact the required provision of the notice. And if it does, you have to give an updated notice, generally 30 to 90 days before the change. And if you can't give it 30 to 90 days before the change, then as soon as possible. And the safe harbor notice requirements are identifying information such as plan name, sponsor name, the safe harbor contribution type, any other contributions made to the plan such as matching or profit sharing, the type and amount of compensation that can be deferred, how to make an election, the withdrawal provisions, vesting provisions, and where to go to for additional information. So how does that impact if you have CARES Act changes? Well, if you opt to allow a corona-related distribution, that is a withdrawal, and that is one of the required changes. That is one of the requirements in a safe harbor notice, and thus would require you to send an updated notice if you opted for that change. If you opt to add loans, loans are not a requirement in the safe harbor notice. Now, it's key to point out that a lot of plan sponsors tend to include more information than required. So they might talk about loans in their safe harbor notice, but that is not a requirement. So even though you opt to talk about loans, since it's not a requirement, even though the change that you're doing might quote unquote impact your safe harbor notice, it's not impacting one of the required provisions, and therefore you actually would not need to send an updated notice under that circumstance. And the same for the RMD changes, which I'll talk a little bit about in the next slide. But if you opt to implement the RMD changes, RMDs are not part of the required notice and therefore would probably not impact the notice itself and require an updated notice to be provided. There have been a lot of relief provided for deadlines over the last month or two, specifically relating to notices required under retirement plans. In Notice 2020-23, which provides a lot of this relief, it specifically states that safe harbor contributions and notices do not fall under this specific relief. So therefore, your notice requirements are not granted any relief. So if you do have a change that's required and an updated notice needs to be sent, you still need to follow the deadlines. So RMDs, or required minimum distributions, again, those were for defined contribution plans. Those were waived entirely for the 2020 plan year. On defined benefit plans, they were temporarily suspended. But for DC plans, it's waived for the entire 2020 year, but it's only for the 2020 plan year. And that would apply to both RMDs that are due if it's your first year eligible for RMDs. So for example, if in 2019 you turned 70 and a half, which was the previous RMD age, your 2019 RMD would be due April 1st, 2020. Your 2020 RMD would be due by December 31st, 2020. Both those RMDs would be eligible for the waiver under this relief. Compare that to if you first become eligible for your RMD in 2020. Your 2020 RMD is actually not due until April 1st of 2021. Therefore, your 2020 RMD, if you're newly eligible for your RMDs in 2020, is not eligible for the waiver. A second point of consideration is the RMD change is an optional change, meaning a plan sponsor can elect to amend their plan to outright waive RMDs for 2020, or they can elect to keep the RMD provisions in there and pay RMDs as normal. And if a participant elects to waive or suspend their RMD, they can waive or suspend on their own. And this is based off of similar relief that was proposed or that was provided under WIRA and in regards to Hurricane Katrina. Also, RMDs that were paid in 2020 are eligible for rollovers, and they're eligible for rollovers under the normal 60-day rollover rules, which mean that if you take a distribution, you've got 60 days to roll it over to another qualified plan or IRA. There's also been some subsequent relief that extends the rollover deadline, and basically if your rollover deadline falls on or after April 1st, you have additional time to make that rollover. Well, it's important to distinguish if a RMD was taken prior to February, so in January, your 60-day rollover deadline falls before April 1st. So those RMDs are no longer eligible for rollover. If you took a rollover beginning in February, your rollover deadline falls on or after April 1st. Thus, you get the benefit of the subsequent rollover relief. So you actually still can roll over your RMDs now for those taken on or later than February. One thing to note is there is some proposed relief being bounced around by the government to extend the rollover deadlines for all RMDs, meaning those taken in January. There might be some subsequent relief for those to roll over, so it's worth keeping an eye out on those. Just a couple of quick notes about the Paycheck Protection Program. The CARES Act provides loan forgiveness under the Paycheck Protection Program, and that forgiveness is not includable in income. So essentially you have free money. But IRS Notice 2020-32 says any expenses associated with forgiveness is not deductible. So it's important to distinguish that while the Pension Protection Program is good, you get some free money, you don't get free money and a deduction. And because of that, it's possible that the Paycheck Protection Program isn't for everybody. Employers may not, one, qualify for the Paycheck Protection Program loan, or if you qualify, may not qualify for forgiveness. In order to qualify, you must take the loan based on current economic uncertainty, and it have to be made in good faith, taking into account all other sources of liquidity. So it's possible that someone might take it and subsequently realize that they don't qualify for the forgiveness, so it's not really as beneficial as they thought. So there's been some relief that's provided, and when I made the slides, May 14th was the date that was the deadline. That's subsequently been extended. It's still already passed. It was extended to May 18th, but there's some rumblings, and given that it's already been extended once, it's possible that it may be extended again. So I thought it was still worthwhile at least to quickly mention. But if you've applied for, received, and repaid by May 18th of 2020, you're essentially treated as though you've never taken a loan for purposes of being eligible for what's called the Employee Retention Credit. And that credit is basically a refundable tax credit against certain employment taxes that's equal to 50% of the payroll cost. And employers can get immediate access to the credit by reducing employment tax deposits, or if the employer tax deposits are not sufficient to cover the credit, they can get an advance payment from the IRS. So I just wanted to point out that, in order to take this employee retention credit, you're not eligible if you've taken the PPP loan. So it might, for some of those employers who've decided that maybe they don't qualify for forgiveness, or this employee retention credit might be better for them. Again, something to keep a lookout on, that while the deadline has already passed, it is possible that there may be a subsequent extension on it. And then finally, a lot of companies, now that states have begun to open up and allow businesses to open up as well, businesses are trending towards operating under, normal operation status, and they might be bringing on employees that they had to lay off, or increasing pay or hours that they had to reduce, or bringing people back from leaves or absences or furloughs. And the last 2 or 3 months has been economically pretty tough, and employers might want to find ways to help their employees become more prepared for retirement. And a couple of those ways that they can think about helping and assisting is by evaluating their investment performances and making sure that the investment lineup currently still is in line with their investment policies and intents, as well as reviewing the current investments and seeing if there's anything that can be done to help stabilize or benefit their participants. The economy is still in a volatile stage, so there's probably not much, there's no surefire bullet that you can do to, guarantee gains, minimize losses, but there could be some changes that you can make to help prevent as drastic of losses, or have maybe a more prudent lineup in there. Second, there's some plan design changes that a sponsor can consider. One would be adding Roth, and that's adding Roth as an option, like a pre-tax or deferral, adding a Roth deferral option, but also adding a Roth conversion option. And one reason that a Roth conversion makes a lot of sense now is, unfortunately, a lot of individuals have taken a hit on their in their retirement account. And essentially, a Roth conversion permits the transfer of pre-tax dollars to Roth dollars, and you pay the tax at the time of the conversion, and essentially you will have tax-free money going forward. So if you have the money to pay for the taxes up front, then because of the loss in the marketplace, you essentially could be doing a Roth conversion on an $80,000 account balance, whereas in 2019 it was a $100,000 account balance. So you'll get a little bit of a break there. Also, most likely, the tax brackets that we're in now probably will change over the next few years as the government's going to have to figure out some way to recoup the relief that they've dumped into the economy these last few months, and probably taxation is a way that they're going to do it. So now is a good way to get, you might be in a lower tax bracket now than you will be in the future. Automatic enrollment and automatic increases, both of these are ways to help promote enrollment in the retirement plan, as well as promote savings in the retirement plan by automatically enrolling participants who don't make affirmative election and automatically increasing those deferrals year to year. And then finally, a lot of employers probably reduced or suspended their employer contributions to try to save money to keep employees paid. And maybe now they might want to look into reinstating those contributions. If an employer had a safe harbor contribution that they suspended, unfortunately, it's too late. You can't add that in mid-year, but you could add that again starting for January of 2021. If you had a discretionary match or profit sharing, that can be added mid-year, and it can be added generally with a simple amendment or notice to your participants. So those are a few things to think about for retirement preparedness. And with that, I will turn it over to Bob to discuss executive compensation.
Yes, I'm going to start with the executive compensation in the context of the COVID-19 environment. So this particular slide, page 25, page 25, essentially provides the roadmap of what I'm going to discuss as the wrap-up, and I'm going to start from a substantive level, discussing separation from service events or criteria under Code Section 409 Cap A. And as many individuals in the audience might already know, Section 409 Cap A governs non-qualified deferred compensation arrangements. And to just get to a very simple level, a non-qualified deferred compensation arrangement is an arrangement where there is a right to payment of compensation that's created in 1 year, but the actual payments under the arrangement are not made until a following future year. So one example would be an agreement in 2020 between an employer and an employee that the employee will be paid, for example, $10,000 per year at retirement age of age 65. And let's assume for purposes of that example, age 65 is 20 years in the future. So there's a right created in 2020 to payments beginning in 20 years in the future. So that's basically what a non-qualified deferred compensation arrangement is. And moving on slide 26, in this COVID-19 environment, one of the particularly relevant considerations is whether a separation from service on the part of an employee has occurred, because under 409 Cap A, payments from a non-qualified deferred compensation arrangement can only be made upon certain specific permissible payment events. And one of the payment events is separation from service. So in the context of the COVID-19 environment, where we have furloughs, reduction in hours, leaves of absence, whether or not a separation from service has occurred, and therefore a payment event has also occurred, is relevant. Now, within the confines of the category of severance from service, there are two instances. One instance is basically a complete separation from service, or a complete severance of the employment relationship. The second category of separation from service, it involves circumstances where at the time of the quote-unquote separation from service, the anticipation of the employee and the employer is that the employee will not be performing services at a level that exceeds 20% of the average quantity of services that the employee was performing for the immediately prior 36-month period. So in effect, that 36 months acts as a look-back period to compare with whether the expectation of the employer and the employee will be that the performance of services will exceed that 20% threshold. And if the anticipation of the employer and the employee at that time is that the level of services that will be performed will be less than 20% based on that 3-year look-back period, then that is considered to be a separation from service and also a payment event. Now, sometimes, as a practical matter, the actual level of services upon that change of status that is performed is different from the initial anticipation on the part of the employer and the employee. And if the actual level of services provided by the employee upon that quote-unquote separation from service is at or below the 20% level, then the employee, under the regulations, is presumed to have had a separation from service, and therefore the payment event is valid and applies. Conversely, if the actual level of services performed is at a level of 50% or more, again, based on that prior 36-month look-back period, then there is a rebuttable presumption that there has not been a separation from service. Now, those, of course, are rebuttable presumptions, and the circumstances under which the presumption may be rebutted. There are a number articulated by the regulations, but one example of where the presumption may be rebutted, that there was no separation from service, is a situation where the employee may have moved to another geographical location outside of the job location, in which case, in that circumstance, then that would be an indication that the intention of the employer and the employee all along was that there would be a separation from service and therefore a legitimate payment event, and the separation from service would be deemed to have occurred, and the payment event then accordingly would be considered to be valid. Now let me move ahead to 28. Okay, so now I want to move on to issues with respect to COVID-19 and non-qualified plan deferral election changes. And the general rule is that a deferral election must be made before the year to which the deferral of compensation applies. For example, if an employee wants to defer 20% of compensation paid in 2020, then the applicable deferral election for 2020 must be made by no later than December 31st, 2019. And in order to be effective, that deferral election must also be irrevocable. Now, the issue that presents is that if an executive is already taking pay reductions, for example, in 2020, because of the COVID-19 situation, then the executive might want to try to opt out or cancel that deferral election. But the problem is that there are only two exceptions permitting cancellation of a deferral election. One is disability. The second is unforeseeable emergency. So in the COVID-19 environment, it's possible to have an unforeseeable emergency situation that would permit the executive in question to cancel the deferral election. But the problem is that under the regulations, the unforeseeable emergency criteria is pretty limited. The unforeseeable emergency must both arise from an extraordinary and unforeseeable event beyond the control of the service provider, and also cause the service provider severe financial hardship that cannot be alleviated by any sort of reimbursement from insurance proceeds or by the liquidation of the service provider's assets. So if a particular service provider does have assets outside of the non-qualified deferred compensation arrangement, such as assets in a taxable account, and those assets can be liquidated, then that probably is not going to present a situation of an unforeseeable emergency. And beyond that, Turning further to the CARES Act and executive pay limits, I think these slides are pretty self-evident, so I'm just going to, in the interests of time, skip ahead to slide number 31. And there are two considerations here with respect to the executive pay limits. One consideration is that if an executive has to take a reduction in pay in order to meet the CARES Act loan requirements, then that can very well present a problem with respect to the compensation that is otherwise provided or called for to be paid to the executive under the contractual arrangement. And there really isn't any guidance on how to address that type of contradiction. And the very, very last issue I'd like to just briefly discuss is that these executive pay limits are framed in terms of limits on compensation received, which presents an issue in terms of whether an executive whose compensation is limited by these executive pay limits might be able to try to, quote unquote, replace the lost compensation by entering into a non-qualified deferred compensation arrangement with the employer, in effect, to try to make up in a future year what the executive has had to have his or her pay reduced under these CARES Act executive pay limits. And again, there is no guidance or elaboration on how to handle that type of situation. One can conceive that replacing current compensation with future non-qualified deferred compensation would be deemed to be a type of gaming of the system or otherwise not in the spirit of these executive pay limits under the CARES Act. And I can see we're a little bit past 2 o'clock our time. So in the interests of time and consideration to the audience, that will conclude my portion of the presentation. And thank you very much.
Okay, great. Eric, Scott, Bob, appreciate you guys taking the time to present this information to our audience. And to our audience, again, thank you so much for joining us. A reminder that you can send questions to admin@hallbenefitslaw.com. We have a COVID resources page on our website. I will send each of you a link to that, as well as some additional resources from the firm. We hope that when you do have employee benefits legal compliance questions, you will reach out to us. And for your benefit, I'm just going to hand you my direct number and I can connect you with one of our legal team. My direct line is area code 470-571-1007. Again, it's 470-571-1007. Thank you all, and we look forward to seeing you at a future webinar. Have a wonderful afternoon.